Section 351 fairly comprehensive, and we think it proper to expressly provide for that situation. Section 351 assumes that the magistrate proceeding under it has the power of taking cognizance of the new case. It does not, however, say in what manner cognizance is taken by the magistrate. The mode of taking cognizance are mentioned in Section 190 and are apparently exhaustive. The question is whether against the newly added accused, cognizance will be supposed to have taken on the magistrate's own information under Section 191C, or only in the manner in which cognizance was first taken of the offence against the other accused. In concrete terms, if the original case was instituted on a police report, that is under 191B, will cognizance against the new accused be supposed to have been taken in the same manner as under Section 191C? The question is important because the methods of inquiry and trial in the two cases differ. About the true position under the existing law, there has been difference of opinion, and we think it should be made clear. It seems to us that the main purpose of this particular provision is that the whole case against all known suspects should proceed with expeditiously, and convenience requires that cognizance against the newly added accused should be taken in the same manner as against the other accused. We therefore propose to recast Section 351, making it comprehensive and providing that there will be no difference in the mode of taking cognizance if the new person is added as an accused during proceedings. Please note, this is of course necessary as already provided that in such a situation, evidence must be reheard in the presence of the newly added accused. The offence for which the newly added accused can be tried is not indicated in precise terms in the section. Obviously, the offence should be connected with the one for which the original accused is under trial, also present tense. To bring that out, a small verbal amendment is recommended. Section 351 should therefore be amended as follows, and then that 319 as it stands today is reproduced. And at page 57, ultimately, it is accepted by the Rajya Sabha. Page 57 at the top, second column, top rank, clause 198 to 319 were added to the bill. So 319 is added by the Rajya Sabha. So there are three parts I've already highlighted. At the top of the page, in the fourth line, it is only proper that magistrate should have the power to call and join him in the proceedings. So the proceedings have to be live. Second, I have already said in the lower half of para 25.81, during the proceedings. And the third is when the proceeding is under trial. So therefore, my lord, that is how ultimately my lord, 319 as it stands, for the proceedings to be live, it is very important. And therefore, what Hardeep Singh holds is absolutely correct. And Shashikant doesn't take that away, because Shashikant is a judgment where 319 was passed in time. And your lordship was faced with a situation where because of the person added going to court and getting an injunction, etc., the proceedings could not continue. And therefore, your lordships found via media that he should not be allowed to take advantage of his own wrong. Now, my lord, I have given in this compilation that I have just given to your lordships some judgments, my lord, where Hardeep Singh has been followed by your lordships, and some judgments of high courts only as a persuasive value, my lord, where your lordships will see where various high courts have taken the same view before and after. And if your lordship will have this compilation at page 1 is the judgment, my lord, of 2017 7 SCC 706. And I must say there is no added discussion. It's just Hardeep Singh has been followed. I mean, so far as the two judgments of your lordships are concerned, Hardeep Singh has been followed. And the first your lordship may kindly have at page 8, para 10 of Brijinder Singh. Para 10 at page 8 says, it also goes without saying that section 319, which is an enabling provision, empowering the court to take appropriate steps for proceeding against any person not being accused, can be exercised at any time after the charge sheet is filed and before the pronouncement of judgment, except during the stage of 207, 208, etc. Then para 11, my lord, is the further what Hardeep Singh says, what is the evidence? And para 12, what is the degree of satisfaction required? Again, I am not actually going into all that because then your lordships have said that your lordship
beyond the reference.
Yes, your lordship will be sending it back. Though the third question referred is, I'll read that. That I submit is completely covered by the rest of Hardeep Singh. I'll come to the third question, my lord. So this is one judgment where Hardeep Singh is followed. Then, my lord, another judgment where Hardeep Singh is followed is at page 35 in 2021 itself. Yes. At page 35, your lordship will see that is not reported in SCC. So I have the SCC online citation for your lordships at page 35. Now again, the page 40, para 33, when the discussion starts, Hardeep Singh is considered. Para 33. While considering the rival submissions, the law on the scope and ambit of 319 is required to be considered. In the recent decision in the case of Sartaj Singh, this very bench has considered in detail the law on the scope and ambit of 319. In the said decision, this court considered the decisions of Hardeep Singh, Mohammad Ispahi, Rajesh, etc. Then, my lord, that decision is quoted extensively here. And after quoting it extensively, right up to page 48, then para 34, the ratio is laid down by the court. At page 48, para 34. It again follows Hardeep. And perhaps it would have to because it's a two-judge bench and Hardeep is 5. So it would. The ratio of the decisions, para 34, on the scope and ambit of the powers of the court can be summarized as under. At page 49, clause 9. Again, after charge sheet is filed and before the pronouncement of judgment, except though it's the same. Now, my lord, some judgments of different courts, my lord, where similar view is taken, high courts, if your lordship wants, I can just quickly take your lordship through, or I have attached 5 or 6 of them, my lord.